Great. Another interesting part is intellectual property rights. Okay. Now we are having 6 to 7 intellectual property rights uh, with us as per legal arena. Okay. Now what is, first you understand the wordings of this. Intellectual property rights. That means I will have some rights on my property which is intellectual in type. That means I will have some right on my property which is in nature of intellectual. So that means I'm not talking about my physical properties like property, assets. I'm not talking about that. I'm talking about which you have created intellectually. And for that, you can capitalize your benefits and you can get money or whatever. You can protect your intellectual things and all. That is, in short, it is called intellectual property rights. Okay. Now, herein many things come one by one. Let me explain. First, patent. Now, patent means, okay, fine. So now in this intellectual property rights, you understand whatever the 6 or 7 uh, uh, verticals are there. These are all to protect your interest. Protect. That means nobody can copy. So the moment I'm saying nobody can copy, the patent means you have created something, invented something new. Instead of created, you talk about something you have invented new, which was not there in this entire world. We are talking about protecting that thing. And therein different patent types are different, like Indian patent is different, European patent is different, American patent is different, US patent is different. Okay, I will talk to you. I will make the comparison in between Indian patent and US patent and so on and so forth. Hold on for them. Now, the moment I'm saying that I'm having the patent on the, let's say, this operating system of this Apple iPhone, that means the same thing I cannot copy, I cannot do it. Samsung cannot do it. Other Huawei cannot do it. That is patented. Patented means I have uh, given all these codes and so on and so forth. What is the utility, applicability, novelness, efficacy, everything I have given or told to the Indian Patent Organization to protect my interest next 20 years. There are 2 types of filing. One is provisional filing and one is final filing. Provisional filing means the moment you have started doing work and all, you think that things are going okay and somebody can copy. Just before that, you just file a provisional patent that I am working on this, it will happen. This is my declaration. And final patent is once your programs and these things are ready, then you can go for patent finally. But only hitch is provisional patent and final patent duration in between should be only 1 year. That means when you're filing for the patent in Indian Patent Organization, within 1 year of the provisional patent, then within 1 year, you need to file the final patent. That's it. That is the only law. And you directly can go for final patent filing also without provisional patent filing. Okay, you have that flexibility. And what is in your benefit? Next 20 years, you will be granted pure patent usability of your product, wherein any other company, individual, they cannot copy you this product and the code and all. Clear? Understood? 20 years or till you are paying every 3 years, you need to pay some 5,000, 6,000 rupees fees as decided by them, and you need to pay for that. This is in short about the patent. Now, I will give you some shocking stories on all this patent. You will be surprised. The patent nature in India and the US is different. In India talks about that you can only get the patent of a product design, programming or whatever, provided that is not in existence across the globe. Provided that is not in existence anywhere in the globe, in the world. But US patent talks about only US. Means if that is not in US, you can get the patent in US. That means if something, even if it is patented or not patented, here in India, you can get the patent in US. Questionable. Surprising. I will not get into that, but this is the policy. And that is the reason you'll be surprised. US has taken many patents from our knowledge. And they started even taking patent of healing mechanism, efficacy of turmeric, which we were using 2003 since last 3000 years. They started taking patent in the year of 1995-96 of neem, not 96, 2016 or 2015, neem, healing property or the anti-infection property of neem. And then our government stopped that and revoked those patents and all from US patent. Understood? In short, what is patent? Next, I will talk about the copyrights. Okay. Copyrights, when we talk about creating or writing some book, you're an author, you're writing some book, you're a painter, you're making and painting. Okay. You're a choreographer, you're creating on dance move and all. Those things, when you are ensuring that nobody should copy, then that comes under the copyright. And in that copyright, book, music, painting, sculpture and films, database, advertisements, maps and technical drawings, anything is possible. Anything, whatever you are creating, drawing, design, anything, that comes under the copyright. But understand, copyright is not mandatory. Even patent is not also mandatory. Copyright is not compulsory. Copyright is not compulsory. Now, I'm going to give you two examples, one for patent, one for copyright. You'll be surprised. Coming back to the patent, what I told you, that programs and the designs of iPhone and all of those things. Tell me honestly that if I tell you that you do not have the sufficient money in your pocket to buy an Apple iPhone, which one will be the nearest of your choice, which company brand phone, which you think that similar or very close to your Apple experience? Okay, so now you know that Samsung is very close to that in terms of applicabilities and the usabilities of the software. Am I right? Apple in the year of 2014 or 15, I can't remember, just ignore that part. Apple sued Samsung in US court for copying one feature of Apple iPhone. And what is that? That zoom facility. You understood zoom facility? So it was not there. Basically, this feature was introduced by Apple itself only. But Samsung copied. I'm repeating it, huh? Samsung copied it. And because of that, Apple should file against Samsung in US court. But definitely somebody will do, because that is the main feature. And it was very surprising that point of time. How come with using two fingers, it is going up, down, zoom in, zoom out and all. Do you know what happened? This fight, almost 7 years, this fight went in US court. 7 years or 5 years. I can't, 5 years maybe. Okay. In 2020, after all of those things, US court called Samsung CEO and Apple CEO. That point of time, who was their Apple CEO? Steve Jobs. Okay. And Samsung CEO, I don't know. I forgot that name. Okay. They called up. Judge asked a simple and straight question to Samsung CEO. I have gone through the entire argument and all, but I want to ask you a simple and straightforward question, and I'm expecting a good and honest answer from your side straight away. That, have you copied this function from Apple iPhone, Apple? Now you tell me, think that you are the Samsung CEO, you fought this case 5 years, and the result is in front of the judge, and everything is visible. All parties, they understand that what could be the verdict and all. Think, under this scenario, you are the Apple CEO and you have been called in court, and simple one question it is asked by the judge, that it is for the sake of citizens or humanity or technology or in economic growth, whatever. You tell me the honest thing that have you copied or you didn't copy? What could be your answer at that point of time? Dharma sankat mein pad gaye na, because you are the CEO, you cannot hit your revenue, you cannot dilute your image, and you cannot also tell very much lie standing on in the court and something like that. And you cannot bypass also. So what answer should be from your side? Think that you are the CEO of Samsung that point of time that day. The answer was he gave, yes, sir. We copied it. And I'm okay. Or whatever you are giving the verdict and punishment, penalty, I'll be accepting that. Case closed, and Samsung was penalized. Let's say I forgot that 100 crore rupees. Example, I forgot the exact amount of that verdict. Okay. Samsung was had to pay 100 crore for this damages of business which has happened proportionately to the Apple for copying that pattern. Fine, he agreed, came out. Then somebody asked one question to him. Sir, you could say no easily. Or why you said 100 crore, you agreed, you could negotiate. So the answer was, first of all, I am here to do business, not to do any fight with legal system. And second one, 100 crores is nothing to me, because of that particular feature, I have gained, made profit or maybe 10,000 crore. I'm okay to pay 100 crore. So business changes, everything got changes, Babu, only because of this patent and all. Because that point of time, it was a patented product for him, for Apple. Coming back to the copyrights now. So patents are secured for 20 years. Copyright is secured for 50 years. Earlier, it was 50 years. Means whatever you write, let's say I'm an author of 2 books. I'm the copyright holder of my books. So even if I die, after my death, 50 years, my son, my daughter, my wife will be my legal heir. He'll be getting all the earnings. If my book is sold, tomorrow my book is used for making movies and so on and so forth. That royalty will come to my pocket till I am alive. And after my death, 50 years, actually it is 60 years, no need to make the dilution in that. 60 years, my legal heirs will be getting the royalty, and after that it will be for public. So patent 20 years, this is for 60 years. But there is a catch. 2002, 3, not 2, 3, 2003. Okay. Before that, it was for 50 years. 2002 or 3, you know who is the writer of Janagana Mana Adhinayaka and all? Rabindranath Tagore, right? So he established 3 universities there. Vishwabharati University in West Bengal, then Santiniketan University, which is a central university, Ravindra Bharati, another university, and something like that, many things. And he was Nobel laureate. And all the copyright related earnings is to go to Vishwabharati University, Vishwabharati University. Okay. Now at the year of 2002, when 50 years are done, then they requested Indian government to change the rule that as Rabindranath Tagore was the Nobel laureate, is a great personality, okay, he should be removed from this copyright list. That means for entire life, Vishwabharati will be getting the royalties for selling books or whatever things. The creation which was created by Rabindranath Tagore 50 years back of his death, and plus during his lifetime. And there is no end. So it will be removed from the copyright law and copyright section. Indian government that point of time in 2002 They declared, no, it is not possible for the sake of humanity and the citizens and the youth. Because if it is protected for only for one particular community or the institute or the university will be getting or generating revenue for the lifetime, that means those work, huge work, literary work, what Rabindranath Tagore has done throughout his 80 years of age, the 80 years of lifetime, it will be completely untouchable by others. People will not be able to recreate things. That is the reason, not only literature things and songs, poetry, everything, whatever I'm telling you. Okay. So that is the reason first time in Indian history of the copyright, IPR, intellectual property rights law, government changed from 50 years to 60 years. That means 60 years, till 60 years, you will be getting copyright. No author or legal heirs will be getting the copyright, and that will be applicable to all of us who are the authors, not only for the Nobel laureate Rabindranath Tagore. So after that 10 years, when again they, I'm sorry, it is not 2003, 4, I think it is 1994. So after 1994, again they, Viswabharati appeared to IPR section and said that please again extend 10 years and all, but they stopped it. So that is the reason in 2004 onwards, you will see that many books are getting published, copied, changed and all. Not only that, after 2004 only, if any one of you have little experience about Rabindra Sangeet, you will see that Rabindra Sangeet style also got changed, and new generation is singing, creating, recreating Rabindra Sangeet. That's those songs. I think another 30,000 songs which he created in his entire lifetime is recreated by new generation in a different mode, different note of music, and so on and so forth. This was the purpose. This was the reason of that. Otherwise, before 2004, it was not possible to copy, create, recreate, and all. This is the story of copyrights and all. Fine, understood? There is another example I'll give you. It is related to the business. Again and again, I'm talking about this Manik Chand Pan Masala. If you know that Filmfare Award earlier used to be sponsored by Manik Chand Filmfare Award. How many of you can remember this? Manik Chand Filmfare Award in Bollywood, right? Now let me give you one simple story about Manik Chand where is now Manik Chand brand? Do you see Manik Chand brand anywhere now? It is gone now. I'll tell you why. Now what happened? Manik Chand became very famous because of that Bollywood that award, Manik Chand Filmfare Award. And they continued almost 10 years on that. In the year of 2002 or 2001, ignore the timeline and all, they became so big, they became arrogant. When you will become more powerful, well, money will come, now you'll be arrogant. It is a normal human being, and that is the reason cycle again starts of declining the life. So they became arrogant. Now what happened? Why I'm saying arrogant? They're in Kerala, Tiruvanthapuram or somewhere. I don't know if someone is from that side, Kerala side, deep south side. There itself another local pan masala manufacturer was there whose name was Manik Chand. And in that local community, local area, it is not very famous or India famous and all. But in that locality, Manik Chand pan masala was very famous. And they were operating there 100 years back. Since last 100 years, they are selling. Their grandfather, ancestors, they were selling that product, and it is so popular around there in Kerala, that particular place. What is there famous in that? In the year of 2000, I think 2 or 1 or something like that, Manik Chand filed a case against Manik Chand Old. I'm just taking Manik Chand Old and Manik Chand New, okay? Manik Chand Old, which is based on Kerala, that they are using their name, new Manik Chand's name, and selling the product. It has to be stopped. And we do not have any problem in that. If they are stopping, good, or they will change their Manik Chand name or the brand out there in Kerala, whatever they are doing it. And no business they can do in the name of Manikchand. This was the problem statement, whatever it was produced in front of the court. So court this analysis, they asked several evidences and all, and they found Manikchand new Manikchand Pan Masala, that company, it was 25 years old. But the old Manikchand is 100 years old almost. They are famous in local market, and these people are famous in terms of in the Indian market and the foreign market based on their money and so on and so forth. Under this scenario, what do you think that which verdict court has given that point of time under this scenario? What do you think? But copyright says that copyright is not mandatory. New Manikchand has taken the trademark on that. That means new Manikchand has the copyright of Manikchand, but old Manikchand does not have the copyright protection for their Manikchand brand. Now what? As per the Patent Act, Copyright Act, copyright is not mandatory and the compulsory, or it is not compulsory. If it is not compulsory, then whether it is new or not, whether it is old or not, whether it is 25 years old or not, I am giving that proof, being an old Manikchand, that I am into the existence last 100 years. Then your new Manikchand's copyright, it becomes itself void and null. If it is void and null, then I am the old Manikchand is the sole owner of the Manikchand brand logo, not the new one. And that is in as per the intellectual property rights law itself. The law says that you need to prove it. If you can prove it, then new person who has got that protection, he will not get. So herein, the old Manikchand's lawyer could prove it very easily. And they got protection, not the new Manikchand. Now what happened? Now old Manikchand lawyers filed the reverse case to the new Manikchand lawyer, Manikchand, stating that, okay, fine, as same thing you filed against us, I am filing the same thing reverse to you. Now you change your name, you change your brand, you should not use it. It's supposed to happen. I don't know which lawyer they hired. You know, I know, with this limited knowledge, because of the muscle power of the money, it happened unnecessarily. And that is the reason since 2002 or 4, ignore that timing. After that, there is no Manikchand presence. It is RMZ, Rasik Manikchand Zaveri or something. RMZ Pan Masala, not the Manikchand Pan Masala.
Hope you have understood the concept of this section. It is clarified properly. You have enjoyed. See you in the next section.